Okay, Ms. Hubbard.
Good morning, Your Honors. May it please the Court. Caitlyn Hubbard for Ferrellgas. This Court and the Texas Supreme Court alike rightly hold the jury trial process in high esteem. They hold in equally high esteem a plaintiff's duty to satisfy the elements of his claim with competent evidence. When the plaintiff fails that task, neither hesitates to require entry of judgment as a matter of law. The District Court erred when it denied Ferrellgas' motion for judgment as a matter of law on the Johnston's manufacturing defect and negligence claims. This Court should reverse for two principal reasons. First, and fundamentally, the Johnstons deduced no legally sufficient evidence of a manufacturing defect that caused the incident, as that claim is defined by Texas law. At most, they established that a propane leak occurred, but under binding authority, a product's malfunction or failure to perform as intended is not evidence of manufacturing defect standing alone. And second, the Johnstons argue that the jury was entitled to relieve them of this burden of, or not find a specific defect under various inferences, including those akin to res ipsa loquitur. The problem with the Johnstons' arguments is both Texas law, the record, and the charge actually submitted in this case preclude that argument.
My difficulty, obviously, you have a unanimous jury here, correct?
A 7-person unanimous jury.
And then the district court denied the directed verdict motion.
Yes, correct.
And there's no problem with the charges. On appeal, you're not saying there's any legal problem with the charges.
No, we have said there's no legally sufficient evidence to support the jury's verdict.
Okay, so that has to be, the evidence was so overwhelming that no rational juror could find these elements.
Yes, we understand the standard, Your Honor.
So not a scintilla of evidence?
Not a scintilla. And the reason for that...
Okay, well, let's go through the elements.
Sure.
The first one would be defect, right?
Yes.
And their two experts, Peterson and Buskey,
Yes.
both said it was profusely leaking because it had deteriorated, and your client chose not to put an expert on. So how is that not a scintilla evidence of a defect?
Well, Your Honor, it's not our client's burden to put on any expert.
Not a burden, but now that you're trying to overturn a unanimous jury and a trial judge and two experts saying we recreated it and it was the seal, I don't see how we would say that's not a scintilla to support the jury on the defect.
Your Honor, they did not recreate it. They tested the tank 6 months after it underwent an explosion and sat on the back porch and found a leak when there was a loose connection.
They said a profuse leak, continuous leak.
Right, and their theory prior to the incident is there had been a momentary leak with a side load and a loose connection.
Okay, well, let's assume I think there's a scintilla that two experts, when no expert opposition evidence is offered, creates a defect. Then we would move to whether it was the producing cause. And when I read the trial, that was a vigorously debated. Mr. Johnston got on the stand and said, I've been grilling for 20 years, and I grill 2 to 4 times a week. And so I don't tilt it, and I don't push a side load.
Well, and Your Honor, I think that goes to a fundamental defect with their causation theory. As you note, their experts said that there had to be 3, and this was unanimous agreement among the experts, there had to be 3 violations of product instructions for this incident to occur. You had to leave the hand wheel open so that gas could flow. Then you had to loosely connect the regulator hose so it's loose. And then you had to have sufficient manipulation to torque that loose connection and cause it to leak. There is no dispute that that was the expert's theory.
But
that
he
was
said I didn't torque it, and the expert said he didn't torque it.
No, the expert said he did. That
Not
he must
beyond,
have.
not to cause a leak. Mr. Buskey?
Mr. Buskey said that we don't know what happened. That he said, under his causation theory, there had to be manipulation. I can give you those precise sites and possibly even the quotes. Let's see. He said, had Mr. Johnston tightened and not manipulated the tank, the accident doesn't happen. He did so 3 different times over ROA 2292 to 95, 2299 to 302.
Well, but you're selectively, that's, you guys argued this to the jury, but Buskey also said at 2282, quote, I think everything he did was reasonable and foreseeable.
And that might go to negligence, and Your Honor, candidly.
So do you fault Sid for anything that he did that day? Quote, no, I do not.
Correct. And I would suggest that that certainly influenced the jury's allocation of only 7% of fault to Mr. Johnston, but it does not change the fact that the experts required manipulation for this accident to occur. What he said, 2304, 2315, 2317, 2320. What we know for sure is we start with a loose connection, we start with the cylinder left on, and then some sort of manipulation of those connection. Those three things to get a leak. Truth? Yes. Again, we can agree there wouldn't have been a leak unless there was some kind of manipulation of that connection, correct? That's correct. There was no dispute that those three things were required, and there was no dispute that those exact same three things can cause an incident like this to occur with a brand new cylinder, a brand new valve, and a brand new O-ring.
So going back, though, to a different point of law that I don't think you've touched on, I thought your argument was that there must be evidence of a specific deviation from the manufacturer's intended design, and that there was no evidence of what was the intended design of the seal.
Yes.
And also that there was no evidence of a defect when it left
Ferrellgas.
the manufacturer.
Yes, Your Honor. If you'd allow me, I'd actually love to speak to your first point. I'll get to the second in a moment. Our argument was that they had to prove, and Judge Higginson, you know well from Casey, I took the liberty of listening to that argument as well, that it's not enough to prove that a product failed or that there's been some deviation from design standards. And what they proved is there had to be a propane leak. Everybody agrees with that. But propane leaks can occur, as both experts testified, when you have the cylinder on, the loose connection, and the manipulation. And I want to explain, because if I were the panel, I would be confused why Ferrellgas relies on newer authorities that say there has to be a specific defect and why the Johnstons rely on older authorities that say no, there doesn't. Let me be very clear about that. There's a reason.
I'm not really asking right now about the defect, although that's significant. I'm asking about the design. Was there any evidence of what was the intended design of the seal?
Not a shred, not one piece. All we know.
I mean, if that's true, then that's the end of the case, right?
It should be. And if you look at Turbines versus Dardis, the Court of Appeals opinion, Casey obviously is a great example. The De Los Santos case by Ford, again, 2013, 2015, more recent cases, are abundantly clear on this. What they say is a matter of logic. You can't prove a deviation if you don't first know what the intended physical construction of the product was. And here is where we get back to the deviation between the two parties' positions in the cases. 1965, we get the restatement second of torts. It imposes strict liability for unreasonably dangerous products, but it has no distinction between a design, a marketing, and manufacturing defect, nor does it have any discussion of a plaintiff prove it. So what happens is we have problems throughout the nation for years. It vexed courts, and we get the authorities, like with the Johnston site, that say things. They do say it. You don't have to prove a specific defect. You can infer defect from malfunction alone.
But I guess I'm not understanding, because the experts here identified a defect. They said it deteriorated, it's too old, it's 17 years old, and therefore it had a profuse leak.
Your Honor, respectfully, they didn't.
They didn't say that?
They said, you know what, it's probably deformed a bit. It's probably dried out. It's maybe shrunken. They had varying theories, just like at the oral argument in Casey, where when you pressed the counsel, they said, well, maybe it was the material. But they did not identify any physical defect in this O-ring at all. They didn't take the valve apart, even though Buskey had said he had done so in other cases. It was speculation. What they did is they began with the premise of, well, it leaked 6 months after it went through an explosion, and so I'm entitled to infer that it predated it. And then they went from there to stack another inference, just like in Turbines v. Dardis, to say, well, there was probably some deformity, maybe it was dried out. But the other side will tell you that they never identified any specific...
If you're right with all the maybes, that would be guesswork, and I'd be more inclined. I don't see any of the maybes in all the experts.
I will give it to you.
Right, they're saying, were you able to identify something that was wrong with any piece of the equipment? Yes. We noticed the valve was leaking.
It was leaking, which is a deviation from performance standards, not a manufacturing defect.
But what does it tell you about the quality of the seal? It was bad. It probably dried out.
Probably dried out. Not that it did dry out, not that they identified a crack, not that they identified that it varied from their circumference, elasticity, brittleness, anything like that in the physical construction of the product. The De Los Santos case versus Ford is exactly on point. There, the argument was this axle became too embrittled and it cracked. And it was a chicken or the egg problem in which the plaintiff was arguing, just like here, well, it was embrittled and it caused the incident. And the defendant said, no.
Just because I know you want to get to negligence, but the third element on the first claim is time of sale.
Right.
And their theory there was that the jury could infer, because Johnston said when he gets it from Lowe's, it's got the cap on it.
Right.
And then he uses it. And then the expert says, well, if it's got the cap on it, you could infer that it was in the condition that it was in when it was sold. What's wrong with that evidence?
I think the evidence is a little bit overstated on the Blue Seal number 1. It's not a full cap. We can look at the photos. We know that. The Johnstons say in their brief that it has a protective function. There's nothing about that in the record. What the record says...
Isn't that a jury question? When the expert says it was therefore in the condition that it was in when it sold, jury can believe it or not because of the holes.
The expert didn't say that. The expert said, I have no idea what condition it was in.
Okay.
That was why they relied on the blue cap and a presumption in the first place. It's 2311, 2329, 2334. He said he had no idea when it became too degraded.
Slowly, again, the testimony questioned to Busk, and when Mr. Johnston takes off the blue cap, because there's been a blue cap over the face seal, is there any reason to believe the condition of that face seal in there has changed? No, none. Jury hears that.
Correct. Jury hears that. And when you ask him, do you know when it became degraded? Can you provide any opinion on that? He says no. And there's kind of a fundamental inconsistency here with the presumptions they want to rely on from new or nearly new products in their entire case theory that it degraded at some point. I want to go back just very quickly and talk about this change in the law. Grinnell issued in 1997. We got the restatement third of torts. Each of those made very clear that you have to prove the distinction between a design defect and a manufacturing defect, and you have to put in the specific intended physical construction. Texas courts weren't following that, and so we got Ledesma in 2007. Ledesma said, you know what, you submitted a charge, you didn't have the proof of a specific defect, and so we are going to make very clear that these 3 rules apply to a manufacturing defect. You must prove a specific defect and rule out other possible causes. You must prove a deviation from intended design in composition or quality from the intended specifications or planned output. And 3, product malfunction or failure to perform standing alone is insufficient. That is the law. And you can find the difference between the cases we rely on and the cases Johnston's rely on because each of them rely or themselves predate or rely on authorities that predate 1997 case in Grinnell and 2007 case in Ledesma. As Ledesma says, we established the standard in 1997. We're requiring proof of specifications and a specific defect, and you must follow it.
Was all of this raised in the district court, including the submission to the to the jury, the charge, and the instruction as to the law?
Are you asking?
Was this all raised in the district court?
Yes.
The points you just made as to Texas law?
Yes, Your Honor. Yes, we challenged whether they had legally sufficient evidence of defect, whether they had legally sufficient evidence of causation, and whether, regardless of those 2 things, they had legally sufficient evidence that a defect originated at Ferrellgas. All of those things were roundly disputed in the trial court. Last thing I will note on negligence, I really think that this devolves mostly into an issue of the defect because the charge submitted required proof of a defect to get to negligence liability. There is one point of a clarification. Just for candor, I want to make sure that we're on the same page with the court on this NFPA visual inspection. Everybody agreed at trial. Mr. Busky agreed at trial that what NFPA 58 requires is a visual inspection. And our counsel asked him, does Ferrellgas perform that visual inspection? Yes, it does. I can get you that precise site. I've got a whole chart of them. But there was no dispute that Ferrellgas complies with NFPA 58. When we got the case and did post-judgment briefing and we raised this issue, that they certainly can't rely on a violation of that, they said, well, you know what? The jury was entitled to read it any way it wanted.
Well, but I thought the point was the NFA only did that because you had all these propane tanks that were 20, 30 years old. So they're saying you actually have to do something.
Right. And The evidence, the full NFPA 58 is not in the record, but the evidence at trial, what it said is, and isn't it true this NFPA 58 was amended in 2017 due to deterioration in the connection? Yeah. And the answer was, yes, that's true. And the question was, and what does NFPA 58 require? A visual inspection. Does Ferrellgas do that? Yes, it does. Really, again, I think this all devolves, and I see my time has expired. This devolves into defect on the negligence issue, but I just wanted to make clear on that.
All right, thank you. Ms. Hubbard, you've saved time for rebuttal. Mr. Davis?
May it please the court. My name is Michael Davis, and I represent the appellees, Mr. and Mrs. Johnston. The district court got it right in denying the judgment as a matter of law for two reasons. First, there was legally sufficient evidence to support the jury's finding on the manufacturing defect claim. And second, there was legally sufficient evidence to support the jury's finding on the negligence claim. I'd first like to clarify some things from the record because I believe they're needed. It's important to note that there were originally three experts in this case: the expert for the Johnstons, the expert for the grill manufacturer, and the expert for the propane company Ferrellgas. When they went to test the product and identify the specific defect, they all went together and they tested it together. When trial came, the expert for the Johnstons testified that the testing showed that there was a gas leak, and the cause of the gas leak was the seal. It was not providing a faulty seal, and that the purpose of the face seal is to keep gas from leaking out. It is the one component part that keeps gas from leaking out of the mouth of that valve. When the expert for the grill manufacturer testified, he testified to the exact same thing. And then when it was time for Ferrellgas to call their expert to supposedly testify that there wasn't a defect, or at least it maybe wasn't the face seal, they never called their expert or anybody to testify that this face seal was not the specific defect. In fact, in closing argument, and this is on page 2453 of the record, Counsel for Ferrellgas said, quote, "There is no question that at least at the time of the inspection in January, there is no question that the face seal did not operate like it was supposed to," end quote. That's their own counsel, which brings me to my first point. There was legally sufficient evidence to support the manufacturing defect claim, and the unrebutted testimony where they're doing testing and identifying the specific issue with the face seal, that alone is sufficient for this court to hold that the judgment as a matter of law was properly denied. But before they can ever get that, they have waived their argument to any method and technique used by our experts in basing their conclusion on the existence of the defect. If you don't object to method and technique in the court below, you forfeit it on appeal. That was held by this court in SEC versus Snyder. If they somehow get past the waiver argument, I believe they might come up and say, well, we objected to causation. But if you look exactly at their motion to exclude, that's on page 380 of the record. In their conclusion and prayer, they specifically said, we are objecting to causation, not the initial specific defect, which is what they argued in their brief and what they argued today. Additionally, when it comes to circumstantial evidence, I think this court will see when looking at Ridgeway and the Fifth Court of Texas in Hewlett-Packard that the biggest factor in deciding whether or not circumstantial evidence is appropriate is how long you've had the product. For example, if you buy a product and the very first day, the first time you ever use it, it malfunctions, well, that's a scenario where circumstantial evidence is appropriate because the probability is much greater that the malfunction is at least some evidence of the defect. And I want to be very clear, we are not relying on evidence of the malfunction alone as evidence of the specific defect, as this court saw in Casey and as the appellants have argued in their brief. If this court will remember in Casey, there the plaintiff got up here and said that the evidence of the airbag not staying inflated was per se evidence of a malfunction and didn't even give a theory, let alone evidence of what was actually defective. Not only did we give a theory, we went out and tested it. Every expert tested it together using a methodology that is actually written in the NFPA. The same regulations that they try to fall back on in their negligence claim to say that they were following industry standards are the exact same regulations that tell our experts what methodology and technique they use in investigating fire. So it's interesting that they want you to rely on the NFPA to defend them in negligence, but they would take issue with the same regulations when it comes to method and technique. It was unrebutted that when, at least at the time of the inspection, that there was a leak. They eliminated all possible sources. I'm citing from page 2279 to 2280, where they say, quote, they eliminated all other sources of the leak and that the only possible source of the leak was the face valve. Manufacturing defect is inherently product specific. This isn't a Ford F-150 that the court was dealing with in Ridgeway that had been through 3 different owners and in the time between it left the defendant and got to the plaintiff. This was a propane tank that Mr. Johnston purchased on July 24th, and then on July 25th, the very first time he ever used it, it malfunctioned on him. This is exactly...
At that point, what was the period of time since it had left the manufacturer?
It had 5 months since it had left Ferrellgas, Your Honor. And 5 months is
And so what's the evidence of the defect at the time it left Ferrellgas?
The evidence of the defect at the time it left Ferrellgas is the blue cap. The defective component of the propane tank was the face valve. There is a blue cap that is placed over that defective component. Our expert testified that he had no reason to believe that the condition of the defect had changed. Furthermore,
But it had been left out in the weather during all that time, isn't that right?
Yes, sir, it did. And just to follow up on any sort of arguments about weathering conditions, I believe that Ferrellgas is probably well aware, and it's completely foreseeable that their propane tanks are going to sit outside. So that would add even more.
I was a little confused about that. At Lowe's, was it in a container or not?
It said it was in the container. I'm also a little bit confused on whether or not it was outside exposed to the conditions.
Well, those stores won't let you take those inside, so they sit in cages outside the stores, do they not?
That's what I believe. So, and
Open cages, wire mesh cages of some sort.
yes, sir. I think that's right. And even if even going there and taking that's the case, that it's sitting outside, Ferrellgas.
Texas laws say a plaintiff has to show, because it's going to be very rare that a plaintiff can say, here's direct evidence of what happened 6 months ago. So what does Texas law require? Is the blue cap container theory recognized under Texas law?
Yes, sir, it is under the closed container doctrine, but also it does not require direct evidence that ruling out all other possibilities that the condition changed. It just
Was the jury instructed on the container law as allowing an inference of this is the condition it was in because it was in a container? Was that what the instruction was given here?
I don't believe that the instructions said anything about the blue cap. I know for a fact that it was stipulated that the valve itself was 17 years old, but I'm not positive that I don't think they were.
The valve was 17 off. No one disputes there was a cap on it. The issue before the jury was, were there holes in the cap? Is that what was litigated?
Not that I believe, Your Honor. I don't think it was conclusive whether it was a completely sealed cap or whether it was a cap with blue holes in it. And I want to be clear, we're not relying on the blue cap alone in terms of evidence that the defect existed at the time it left the manufacturer. Some more evidence that the defect likely existed at the time it left Ferrellgas is their own corporate rep. So on page 2112, we showed the corporate rep pictures of the cap, the face seal in its current form. And he said, I don't see anything wrong with that. That would pass our inspection today. So looking at the exact propane tank that we just tested, and we proved that it had a leak and there was gas coming out, and the component part that's responsible for keeping that gas in is the face seal, even if its current form right now, their corporate rep is saying, I see no issue with that, it would make it out of our visual inspection today. And I believe that adds evidence to the fact that it likely passed inspection at that time with that defect intact.
This is completely a manufacturing defect, not a design defect.
That's right, Your Honor. And the evidence that we show that it deviated from its design, the first evidence I have is on 2279, where they asked him about the quality of the seal. Remember, the rule is whether or not it deviated in construction or quality from other products of the sign. He said the quality of this seal is bad, and that he believed it was dried out. On 2307, opposing counsel.
But that's a manufacturing defect, right?
No, Your Honor. He was stating that it had dried out over the years after it left the manufacturing. He left the original manufacturer, not Ferrellgas's control. When it was originally manufactured, we have no argument. In fact, our expert said the opposite. He has no reason to believe that it was originally manufactured or designed inappropriate, but we do have reason to believe by the time it left Ferrellgas.
That's the refiller.
Yes, Your Honor.
Your theory here.
Yes, Your Honor.
Ferrellgas refills these tanks year after year after year.
Yes, Your Honor. And we take no issue with their business plan of wanting to recycle their old products. But if they're going to be in the business of selling products, they have to be in the business of selling safe products. And when they're putting out products that have a gas leak and they fail to do a single leak test or have any policy on the appropriate lifespan of these propane tanks, then
that's my difficulty a little bit, and it goes more to the negligence claim. And what is their standard of care, and what did the jury hear it was? Because opposing counsel points out they complied apparently with the only standard out there, visual.
Yes, Your Honor.
Respond to that.
Well, first,
could they have done more than what is required of them? And what more would there have been?
They could have done a leak test.
With the regulator.
With the regulator?
But didn't the expert say he doesn't know of any? Well, there are only 2 refillers in the country, right?
That's exactly right.
But he did say no one's doing that.
He said out of the 2 people that do it, that's right. He doesn't know anybody that's doing it.
So was your theory to the jury, the standard of care here would be you just have to have some maximum shelf life? Or was it that you have to take it apart when you visually inspect it? Or was it that you have to use a regulator? Or was it something else? What was the standard they didn't adhere to?
The standard that they didn't adhere to was not performing a leak test. Whether they use a regulator or whether they do the soapy water experiment that they tell all the customers to do themselves, we're just asking them to do a leak test before they send it out. And these regulators and these tools that our experts are using, they're readily available. And the Supreme Court of Texas held in American Tobacco that just because everyone else in the industry is not providing or not using technology to catch the defect does not excuse the omission of using that technology that would easily catch the defect. I think that the jury saw that what we're asking, what the Johnstons are asking for is completely reasonable. Just do the same thing that you're telling all of your customers to do. Hook up a regulator or do some sort of test on whether or not there is a leak. But that is not what Ferrellgas does. What Ferrellgas does is they look inside the valve, they just with the naked eye eyeball it, they might slap some paint on it, and they send the propane tank out on its way and pray that it doesn't kill somebody. And if it does, then maybe they'll change the seal. But currently they have zero policy in place. And so I just want to make sure that I answered your question, Judge Higginson. So we have multiple independent grounds for why they were negligent. One, they failed to do the leak test. We proved that this gas tank had a leak. If they would have done a leak test, then they would have caught it. But they didn't do.
You're not saying the standard of care is there actually for these propane tanks at some point, 20 years out, you can't keep refilling them, you being Ferrellgas. That isn't your argument. There's a maximum shelf life. It's you could go on forever, just as we can fly planes forever, I guess, maybe, maybe not, as long as you rigorously test them as they get older and older and older.
We are arguing both independently. One, we're arguing you got to have a leak test. And the other independent ground that we're arguing is that that you should have at least some semblance of an idea of when a maximum lifespan is on these face seals. NFPA says you have to recertify the entire propane tank every 12 years. That would certainly be a good use. And also, opposing counsel said that we did not dispute whether or not they complied with the NFPA. That's not true. We 100% absolutely did dispute that they complied with the NFPA, and I think you'll see that in the testimony of the experts and the corporate rep. We said that a visual inspection requires not only for you to look in the mouth of the valve and look at it from the outside, or it also requires you to look on the other side of the face seal to see if there's any deterioration. And it's important to remember that the NFPA in 2017 issued an amendment to their regulations that said that they had seen a growing pattern of deterioration in these face seals. And that's exactly what our expert testified had happened. On page 2279, where he says it's dried out, 2307, he says it's deformed. Multiple times he says it shrunk from age and wear and tear to the point.
Did he say, though, probably and maybe and start getting into guesswork?
He did not get into guesswork. He did say probably. That is true. But Justice Hecht wrote in Ridgway that the plaintiff does not have to eliminate all possible sources. He just has to reduce the other causes to the point where it's more likely than not negligence at the defendant's door. And here we have reduced it not only down to the valve, but down to the very face seal, and we showed that the face seal is not providing a proper leak. And I want to address any concerns about this post-accident condition versus pre-incident. There's no evidence that this face seal was destroyed by this fire. In fact, their corporate rep is saying the exact opposite. He said it looks fine to him. And I want to make clear that in their brief, they mention a quote about boiling rubber. That is where our expert was talking about the hose that connects from the grill to the propane tank. He didn't identify any fire damage to the face seal, and there's no evidence of this fire damage in the face seal. Furthermore, they don't cite a single case or a study that says post-incident testing is zero evidence of a defect or in the product. In fact, the NFPA has been adopted by the Texas Railroad Commission and lays out the guidelines of how you...
The counsel said in terms of producing or causation, producing act, that it's undisputed. The experts agreed that Mr. Johnston didn't tighten it up correctly.
That's right, Your Honor. And I'm glad you brought that up because we don't run from anything the experts said. We accept the good and we accept the bad as well, and so did the jury. And the jury apportioned liability to Mr. Johnston. The jury apportioned 7% liability. The experts went on to say that they saw that what Mr. Johnston did was reasonable and it was expected, and that sometimes that happens, that you don't tighten the connection all the way. And the jury heard that evidence. They heard all of their evidence about other contributing causes in addition to the defect.
What are you supposed to do? Over-tightening and then come back 2 or 3? I don't grill. What are you actually supposed to do when you tighten?
You're supposed to hand tighten it until you can't tighten it anymore.
Okay, that's where you stop.
Yes, Your Honor. Hand tighten until you can't tighten it anymore. And our expert did say that if he had hand tightened it until you can't tighten it anymore, that even with the bad seal, the gas would not get out. Now, if you unscrew it, at that point, the bad seal is still going to have an impact, because now you're unscrewing it and the bad gas could get out. And we do not run from that. We do not run from the fact that there was a loose connection. And the jury did not run from that either. They apportioned liability to Mr. Johnston to 7% and apportioned Ferrellgas 93% responsible. This is just an attempt for them to relitigate the exact same issues they did in the court below. The jury heard this evidence. Judge Pittman heard the evidence on the 50A motion, denied their judgment as a matter of law on the 50A. He denied their judgment as a matter of law on the 50B. The jury heard the evidence and found unanimously that Ferrellgas was both liable for manufacturing defect and negligence. And it is for these reasons this court should affirm the denial of the judgment as a matter of law.
All right, thank you, Mr. Davis. Ms. Hubbard for rebuttal.
Yes, thank you, Your Honors. I want to start with Whirlpool versus Camacho. Conclusory or speculative opinion testimony is not relevant evidence because it does not tend to make the existence of material facts more probable or less probable. We are not running from the standard of review either. But in Cooper Tire, in Camacho, in Casey, and Turbines, and De Los Santos, each of those had expert testimony too. And the problem we are having in this case is that we are throwing out argument without actually looking to see if there was any basis in the expert opinion testimony. Moving on to that issue. It is a problem when an expert doesn't explain why he relies solely on a propane tank that has 11 months after it left the manufacturer and 6 months after it underwent an explosion, is relying on that alone to say that there must have been a pre-accident defect. And you don't have to take my word for it. Typically, in products cases, this is the central issue. Did the accident cause the problem, or did the problem cause the accident? Ledesma, asking when and why this malfunction occurred and whether it caused a collision or resulted from it was the central issue. Volkswagen of America versus Ramirez, did the wheel bearing fall off because of the accident, or did it cause it? Same with De Los Santos from the San Antonio Court of Appeals. It is not enough just to presume that because this thing was causing a leak 11 months after the incident that necessarily there was a pre-accident defect, and you can't get around that just by saying it's so. That is what is conclusory and legally insufficient evidence. With respect to the probablys and the maybes, 2279, Judge Higginson.
What? What is this?
ROA 22.
What's the point? Sorry, I couldn't hear.
This is Mr. Buskey. The question was asked about the state of the seal, and he said, it's bad. It's probably dried out. He had a different theory at page 2307. The question, let's talk about the face seal. So your theory is that the face seal shrunk, no longer dried out, shrunk from age and wear to a point where it wouldn't provide a proper seal. Is that right? Yeah, it probably has deformed a bit. Then again, separately, on ROA 2311, it's your theory that at some point the face seal degraded or shrunk to the point where it wouldn't provide a proper seal, right? Answer, that's correct. And then to your separate point about when that originated, the next question was, but you don't know when it got to that point? Answer, that's correct. So you're not able to testify under oath that the face seal was in a condition where it had shrunk to the point where it wouldn't provide a seal when it left Blue Rhino, because you don't know when that happened. Fair statement? Answer, yes, that's a fair statement. This is the issue we're having in this case. And more to the point of when it originated at Ferrellgas, they say we don't have a process for identifying these. There is the compliance with NFPA 58. There also is a leak test because Ferrellgas has to refill these tanks under very, very high pressure. And the uncontroverted testimony was it's going to be very apparent if there's a leak. I point you to Cooper Tire on this particular issue, where the Texas Supreme Court said further, Grogan offered no theory as to how the tire could be used for 30,000 miles and suffer a nail puncture at some point without failing if wax was improperly deposited on the skim stocks. Here, the Johnstons and their experts offered no theory of how Ferrellgas was able to successfully refill the tank under extremely high, much higher pressure than you'll have at home and residential use if there was a defect that existed in it at that time. There is a fundamental mismatch between the claim asserted and the evidence that exists in this case. Now, they want to rely on res ipsa, which was something, again, that came up post-trial. The jury was not charged on res ipsa, not at all. There is no evidence from any expert in this case that this is the type of accident that would not ordinarily occur in the absence of a defect. As both experts agreed, it absolutely can. And that's the sad reality, but it is the reality of products liability, that they are not always completely fail-proof. And that's where you get into a design defect theory. And if you look at the expert's testimony, really what they wanted to say and what they said with respect to a loose connection was, well, I would think that a consumer should expect that this can't happen, even if you don't tighten it the way that you're supposed to. That's a design theory. And that's why they bore the burden, to your point, Judge Smith, to put in specific specifications of the construction of this seal. If they thought it dried out a bit, examine it. If they thought that it shrunk a bit, examine it and compare that to the product specifications. Ledesma maps a good outline of how you prove your claim in these circumstances. You get the technical specifications, you look at them, you look at the product, you talk about what you think might actually have been caused by the accident or what might have pre-existed it. None of that happened in this case. It was inference stacked upon inference. We'd ask the court to reverse and render.
Thank you, Ms. Hubbard. Your case is under submission. The court will take a brief recess before completing